Good afternoon, everybody, and thank you for joining us on this edition of the OG Energy Education series titled No JOA, No Secondary Term. Thank you all for joining us today. We're pleased to see you all again. By the way, kind of interestingly, this is a record-breaking registration for this particular webinar, which I think speaks more to the fact that this is an interesting topic for the industry, more than anybody cares what I personally have to say. I will also say, in the spirit of full disclosure, my firm has a sort of a little bit of influence, I guess, or a little bit of involvement in some of these lawsuits, particularly the Cromwell matter that's pending before the Supreme Court right now. This has to do with the Anadarko Washout. Professor Chris Kulander at South Texas College of Law is of counsel with our firm. He wrote an amicus brief in this case. There was a filing yesterday related to the petitioner's petition for the Supreme Court to hear the case. They actually attached a prior version of this presentation that I did for the Denver Association of Professional Landmen. They attached the entire presentation to the filing, which I thought was kind of interesting, and not so much because of the substantive, portions of this. And I try hard here to give a sort of measured, balanced view of what's going on with this, but more to show that the industry is paying attention, that the industry cares about this topic. Obviously, there's a lot of non-ops that have a great deal of interest in this, a lot of lease maintenance questions that are lingering out there. And in a prior iteration of this suit, or of this topic, I should say, the Cimarex case, which I'll be talking about, the Supreme Court declined the petition for review. So they declined to hear it. They kind of tacitly endorsed Anadarko's position. And now we've got another opportunity for the Supremes to hear this case, to kind of look at this topic again, and to tell us what the future of the Anadarko washout may be. On that note, the term Anadarko washout is something I coined. I don't know that anybody else is calling it that. No offense to our friends at the company formerly known as Anadarko. It just so happens that both the Cimarex case and the Cromwell case involved Anadarko entities. They seem to be out there kind of using this proactively and kind of pushing this agenda. If we have time today, I will also talk about the Dorchester case, which is a kind of an interesting, unrelated case, related to the extent that it deals with non-op interests and JOAs, but it has to do with adverse possession. It's also currently pending before the Supreme Court, so keeping an eye on that one as well. Since I forgot to do so earlier, by the way, my name is Brad Gibbs. This is the Oliva Gibbs Energy Education Series. I'm a partner here in Houston. Thrilled again to be with you guys today. So recently, the Texas 8th Court of Appeals out of El Paso has issued a couple of decisions affecting the termination of a lessee's lease in the absence of an operating agreement or a JOA, where the lessee held a non-operated interest. So this kind of particularly deals with non-op interests, and I think is of particular relevance to non-ops in the state of Texas. These decisions create what looks like a very high bar for what a non-op lessee must do to keep their leases alive and what it means to cause production. I'll be circling back to this a couple of times, this idea of what it means to cause production and who actually has to cause the production. The 7th Court of Appeals out of Amarillo has also issued an interesting decision concerning adverse possession. That's the Dorchester case. Again, if I have time to get to that today, I will talk about it a little bit at the end. If for any reason I don't, you'll be getting a copy of these slides. By the way, you can download a copy of both these slides and the AAPL affidavit of attendance on the GoToWebinar little pop-up drop-down thing that you see on your screen. So those are there, and I encourage you to go take a look at my kind of brief write-up on that case, the Dorchester case. Should I not have time to get to it. So we'll talk about these cases. I'm going to run through the petitions to the Supreme Court, the arguments that are being kind of set forth, and how these issues can be avoided regardless of the outcome of the current cases. So what we're going to be talking about today is what needs to be done to keep a lease alive as a non-op working interest owner, whether this idea of sharing in the costs, risks, and liabilities of E&P is enough. As we're going to find out, at least per the Cimarex court, it might not be. And Cromwell is very much addressing these questions dead on. So who has to produce? Who has to cause the production? And finally, can a non-op working interest be adversely possessed? So to start with some basics, let's just make sure everybody in the audience today knows what we're talking about when we talk about a joint operating agreement or a JOA. Also, I think it's good to review some of these principles when sort of thinking through why these cases have played out the way they have up until now. So an operating agreement is an opportunity for lessees to join together and designate one of the parties to act as an operator and conduct drilling operations. Obviously, all the parties that are not the operator are going to be non-ops. Helpful, the JOA is helpful because it prevents, in many instances, joint and several liability, or it limits, your exposure, and is kind of an agreement to how that's going to play out. So it's also an agreement to share in the expense of development, and it should describe the proportionate costs and liabilities to be shared by the parties. So it'll set forth kind of the contractual interests in the contract area that's typically described in the exhibit, and kind of who owns what leases they're contributing, and what interests they're going to own in production. Could be limited by depth, could be before and after payout. There's a number of different ways these are put together, but that's kind of what the operating is at the high level. So if a lessee joins in a JOA with a co-tenant engaged in production, that agreement fulfills the lessee's requirement to cause production and perpetuate the lease. I'll pause here because this is a very important principle to our discussion today. The idea that nobody really disagrees that at the very least, if you have signed an operating agreement and there is production on the contract area, your leases are going to be perpetuated. What we're really talking about today, particularly with the Cimarex and Cromwell cases, is what happens if, for whatever reason, an operating agreement was never signed. So as I said, the other lessees are, of course, the non-operated or non-op interests. And, think of JOAs as, in essence, a way to avoid or contract around the default principles of co-tenancy. So, co-tenancy obviously has been around a lot longer than the oil and gas operating agreement. Many of these co-tenancy laws date back to, Old English common law, were brought over here. They're archaic, but they kind of define as a base, at the base level, what the relationship will be between the parties. They help you avoid kind of falling into the trap of becoming a mining partnership or a joint venture inadvertently. And, again, this is an important principle today because a lot of what I'm going to be talking about today is this idea that is it possible that co-tenancy maybe creates kind of this default operating agreement or this kind of fallback operating agreement that possibly could be utilized to extend a lease. So I'll be talking a little bit more about that. On the topic of co-tenancy, note that many states have a robust compulsory pooling scheme, and it kind of, in those states, the compulsory pooling acts kind of create a default operating agreement. They provide terms related to risk penalties, consent balloting, joint and several liability, a deemed royalty for unleased interest, a lot of these concepts that might be captured in an operating agreement. So in a lot of states like, North Dakota and others, you might see operations being conducted without an operating agreement. They can be kind of redundant unless the parties are trying to agree to some, other special arrangement. So it's not that you never see them, they're just not used as much because it's kind of covered in the Pooling Act. As many of you out there know, Texas does not have a robust compulsory pooling scheme. We have MEPA. MEPA, it comes up somewhat. It's actually come up a few times recently, but it's not used as aggressively as pooling, as forced pooling in other states. So let's just say it's not common at all, and therefore Texas has developed this idea of operating agreements, of co-tenancy, and we've sort of hashed out these laws and these agreements a lot more than some other states. And this law of co-tenancy dictates the relationship between parties who own undivided interests in the same tract of land. So, again, one other way to look at this is the common law of co-tenancy could be viewed as kind of a default operating agreement arising from the common law that governs the relationship of the parties in the absence of, an operating agreement that contracts around the common law of co-tenancy. Another way to look at this is it's kind of similar to the law of intestacy creating a default will. If you die without a will, it's not that your estate just disappears or escheats to the state. Obviously, there are the rules of intestacy which govern where your assets will go and create this kind of default will. So as a general rule, in the Texas law of co-tenancy, any co-tenant is entitled to lease or produce without the consent of the others. However, the producing co-tenant has to account to the non-consenting co-tenant. So there's this duty to account, okay? Therefore, a non-consenting co-tenant may be charged with his share of all reasonably necessary costs of production. This includes lifting, drilling, development costs. Another way you sometimes hear this say is they're carried until payout. So they don't come in, they're, all of the interest allocable to them goes to the operator until the costs of drilling the well are recovered. Under co-tenancy, there's no risk penalty. So this would typically be set out in the operating agreement. It would typically be set out in the force pooling statutes in other states. And a risk penalty just says, this is a little extra, a little bonus that the operator gets for shouldering the risk of drilling a dry hole or a marginally producing well. There's a lot of different ways risk penalties can look. It might be, you get to recover 150% of your costs, 200%, all the way up to 400%, and anywhere in between. So you're going to hear me give you a few hot takes, and I'm labeling these throughout this presentation so that it doesn't sound like I'm saying this is the right way to look at it. This is the only way to look at it. These are very much my own hot takes, and I wanted to make sure they were clearly labeled as such, lest anyone think I'm out there, pretending to have the definitive answer on a lot of this stuff, because there is no definitive answer, at least not yet. So my hot take here is, could this mean that a non-consenting co-tenant is at least indirectly sharing in the costs of drilling and equipping the well, even though they aren't technically participating? What I'm getting at here is back to the idea that, does co-tenancy create enough of a relationship between the parties that even in the absence of a JOA, it's possible that a lease could be extended? So again, talking a little bit more about Texas co-tenancy, remember that an oil and gas lease is a contract and a conveyance. It is a fee simple determinable with the possibility of reverter. So that basically means that the deed or lease or conveyance is as good as long as a particular event is happening. And as soon as that event stops or ceases, then the interest will revert back. So the original grantor or lessor, continues to have this presently vested interest called a possibility of reverter. And that means just what it sounds like. There's the possibility that the interest may revert to them at some point in the future. It probably will, but for properties that have been held by production for years or decades, this could be a very indefinite point in the future. So therefore, the lessee of a fractional mineral interest steps into the shoes of a co-tenant. Again, an important concept, because we're saying a lease is a conveyance. It's fee title. You step into the shoes of the co-tenant. You therefore become the co-tenant, subject to all of the laws of co-tenancy. Each co-tenant may enter upon the premises for the purpose of exploring for oil and gas and may drill and develop the premises. Per the Wilson case, all the way back in 1954, in the absence of a joint agreement, upon discovery of oil and gas, the producing co-tenant must account to the non-consenting or non-producing co-tenant for his pro rata share of the net profits. So the Wilson court, all the way back in 1954, said, look, you don't have to have a joint operating agreement to drill a well. We've got the rules of co-tenancy. You're welcome to contract around those rules in the form of an operating agreement, but nothing says you have to have one. All you have to do is make sure that you account. So is the court potentially saying here, in the absence of a JOA, that co-tenancy may in fact create a common law or sort of a substitute JOA? Again, nobody's ever said this expressly. The Supreme Court has an opportunity to weigh in here. But again, this is just sort of, talking about the history and kind of how this has been treated in the past. So then could a non-op lessee get to possibly take advantage of this common law or default JOA concept for lease maintenance purposes? Again, an open question. So let's talk a little bit about Texas and how it likes to handle oil and gas leases generally. We like to honor contracts between parties. We typically, as a state, in the history of our jurisprudence, we don't like to strike down leases. We don't like to strike down portions of leases. We like to leave it up to the parties to freely contract, as to what they want their rights to be. So an old legal maxim is that equity abhors a forfeiture. This means that, unless it's very, very clear, Texas courts don't like to swoop in and eliminate or forfeit people's leases unless they very clearly agree to some forfeiture event happening. So courts have been very strict about what we call special limitations, and these are just limitations in an oil and gas lease that eliminate all or a portion of the lease. Courts are very strict about these, even if it's just a portion of the lease, much less the entire lease. You see this a lot in the rolling versus snapshot lease termination cases. There's been a number of them in recent years. And what that means is, if you've got production on different proration units on your lease, the lease goes beyond its primary term, the production goes down on one of these designated proration units. Do you lose that unit on a rolling basis, or do you get to kind of take advantage of a snapshot in time? And as long as one lease continues to produce, then all the leases are going to continue to produce. So obviously, again, the parties can contract to whatever they want, but courts have said, look, if you want this to be on a rolling basis, your special limitations should include clear, precise, and unequivocal language to that extent. If you don't have that in there, then there's a good chance your lease is going to be held as to all proration units by production on a single portion of the lease. Another interesting side note here is that Texas in recent years has taken kind of an anti-washout stance generally. So the Texas legislature somewhat recently rebuked the washout of certain oil and gas interests, specifically overrides. So effective as of September 1st of 2023, there is now a cause of action in the Texas Property Code for the bad faith washout of overriding royalty interests. However, we don't have that type of protection currently for the washout of a working interest, which is what we're talking about today, whether or not it's in quote unquote bad faith. So what is bad faith then? Well, it's the conscious taking of action for the purpose of washing out all or a part of an overriding royalty interest. Washout, of course, means the intentional elimination or reduction of an override in an oil and gas lease by the forfeiture or surrender of the lease and the subsequent reacquisition of a lease. So, put more plainly, it's letting your lease expire and immediately taking a new lease to get rid of overriding royalty burdens that were on the old lease, therefore elevating your NRI. And so what you'll see in a lot of override conveyances in the modern age is what's called an anti-washout clause that might say, any lease taken within a particular amount of time, this override is going to continue to burden that lease. And again, it's to protect against this intentional bad faith washout of overrides. And here's a question: is it really different than if you're washing out kind of on purpose a non-op working interest by allowing the lease to expire, refusing to sign an operating agreement, and then immediately turning around and taking a new lease and not granting them an interest in this new lease? So you've purposefully eliminated their interest. One could argue that this might be in bad faith. So what is the Habendum clause then? Well, it defines the duration of an oil and gas lease. It typically will contain a primary term and a secondary term. Primary term, an example might be 3 years, 5 years. You see all the way up to 10 years in federal leases sometimes. And secondary term, could last for a few months, a few years, or it could last for generations. We've seen leases held, for 100 years. So of course, what we're talking about in these Cimarex and Cromwell cases, which I'll be turning to shortly, is the secondary term. The typical generic secondary term of a lease is for so long as oil and gas is produced in paying quantities. Looking back for a moment to my fee simple determinable discussion, this would be the idea that the fee simple is held as long as there's production. At the time that production ceases, the possibility of reverter kicks in, the interest reverts back to the lessor. So there's two types of habendum clauses that you might run into. These are not necessarily legal terms of art, but I will use them here to kind of distinguish the two. There is the passive habendum clause that says the secondary term lasts as long thereafter as oil and gas is produced. So non-restrictive as to agent. What I mean by that is it doesn't matter who produces, or at least that's what the lease says, because it's not restrictive. It doesn't say the operator has to produce. It just says that there has to be production. It's passive. Then there's the active habendum clause. The secondary term lasts as long thereafter as oil and gas is produced by the lessee. This is restrictive as to agent. It could be the lessee and their successors are assigned, whatever that variation might look like, but it's restrictive as to agent. So we don't have that kind of passive, like, hey, all we need is for there to be some production. We need some specific agent to cause the production. So a few more hot takes. Again, I tried to label these everywhere I could. So if a JOA is sufficient to satisfy this requirement, then is it possible that passively contributing to a well by being carried until payout as a co-tenant with no JOA, or maybe a default kind of common law JOA, should also be enough? Maybe you can distinguish this idea of a default JOA under the co-tenancy laws and a constructive JOA, or finding for a co-tenancy plus agreement where there is none. This was heavily argued in the cases, which is why I bring this up. They're looking for the way for the courts to say that there's a course of conduct argument for there being a JOA between the parties, even though they never formally signed one. And I guess what I'm saying is distinguish that from the idea that you need a JOA at all if maybe there's this idea that the laws of co-tenancy create a default JOA. Under an absurdly strict or pro-forfeiture reading of an active habendum clause, is signing a JOA even enough? So, if you're really going to go down that path and say, and you have an active habendum clause that says that oil and gas has to be produced by the lessee, and you are the non-op under a JOA, could it be argued that's not even enough? It's not actually you going out and drilling the well. I'll mention this again, but you can see language to that effect occasionally. Think of the Eagleford and the anti-Chesapeake clauses, as they're sometimes called. Again, no offense to our friends at Chesapeake. I did not coin the term, but there are clauses out there that specifically try to avoid the lease being assigned to a operator that the lessor has, some idea that this person might not be, a good operator or an operator they want, or maybe there's been a dispute in the past. So you can certainly draft leases to exclude particular parties, but again, that's not typical, and most of the time, I think habendum clauses are not meant to be that restrictive. So again, we'll be talking about the Cimarex case, the Cromwell case, and the Dorchester case here at the end. So let's jump right into Cimarex. This is a fun case. This case came out a few years ago, caused a lot of raised eyebrows across the industry. So what happened here was Cimarex leased a 1/6 interest, an undivided 1/6 in 440 acres, and Anadarko leased the remaining 5/6. So the two were co-tenants. As we said before in the Wilson case, they stepped into the shoes of the mineral owners by executing a lease, and they then became co-tenants. They held separate oil and gas leases on the same property. Anadarko refused Cimarex's request to participate in the wells and sign a JOA. Anadarko then drilled 2 wells on the property, which each paid out during Cimarex's primary term. So again, Anadarko here flat refused. Cimarex said, hey, we want to sign an operating agreement. Anadarko said no. So Cimarex then sued Anadarko for an accounting, resulting in a settlement agreement. This was a prior lawsuit, okay? So this Cimarex versus Anadarko suit that we're talking about today was kind of like round 2 between these guys. They had sued before, resulting in this settlement agreement. Now, there was still no operating agreement between the parties. The only agreement was this settlement agreement. This was all, by the way, during the primary term of the leases. Then the primary terms expired. Anadarko stopped paying Cimarex and took a quote-unquote top lease on Cimarex's mineral interest. Now, I've got top lease here in quotations because Cimarex would obviously argue this was a top lease. Anadarko just said, no, this is just a new lease because your lease had expired. So Cimarex sues again, alleging a breach of the settlement agreement. They said, look, guys, we had the settlement agreement. We thought everything was squared away, but now you're telling us that our leases are expired. You still never let us sign a JOA. This seems completely unfair. They sue again. So the trial court holds that Cimarex's leases did in fact expire, and Cimarex appealed the decision. So let's look for a moment at Cimarex's Habendum clause, the clause in their leases. Standard passive or non-restrictive clause, a primary term of 5 years, and as long thereafter as oil or gas is produced from said land or from land with which said land is pooled. So Anadarko here argues that Cimarex had to actually drill or operate their own well. Cimarex was unable to passively rely on Anadarko's development to perpetuate its lease in the absence of a JOA. Cimarex came back and said, no, we didn't have to directly cause production on the property to keep our lease alive. We can rely on Anadarko's production. This happens all the time. Production is production. So there was also kind of this side argument that the settlement agreement from the prior case kind of became an operating agreement, proxy, or took the place of an operating agreement. The court was not persuaded by that argument. So the Court of Appeals held that despite the passive voice of the Habendum clause, again, as long as there is production, Cimarex was required to take some action to cause the production. The court held that Cimarex could not rely on a co-tenant's production to keep its lease alive without a JOA. The court didn't really care that Cimarex had made repeated attempts to enter into a JOA. Without a JOA, they were merely co-tenants who owed no duty to one another. So what the court said was, look, Cimarex, you knowingly took the risk that another co-tenant might refuse to sign an operating agreement. If somebody does refuse to sign an operating agreement, there's very little recourse. There's not much you can do. Your hands are kind of tied. But for the Court of Appeals, Cimarex knowingly took this risk. And the court also rejected the idea of an implied or constructive JOA. So again, this will come up over and over again, and I want to distinguish this between, or from the idea of there maybe being an argument that co-tenancy itself defines the rights of a party. They're looking to actually have the court say, you guys effectively entered into a JOA through your course of conduct. Cimarex, of course, was a big shot across the bow for non-ops, for non-ops. They were scrambling to make sure they actually signed that JOA. A lot of them probably looked around and said, man, do we have a copy of that actually has our signature on it? What happened here? Kind of going back through emails and records. It seemed to set the stage for a well-capitalized operator to force out its non-op co-tenants by refusing to sign a JOA. The Anadarko Washout, as I'm going to refer to it throughout this presentation, does kind of seem right for bad faith abuse by well-capitalized operators. And again, we've seen the Texas legislature kind of take a stance against bad faith washouts, but now we see the courts kind of endorsing this practice, maybe without saying so expressly. So after Cimarex, there was a petition for review filed with the Supreme Court. The Supreme Court denied it. They said, we don't see any reversible error here. It looks like the right decision was made. So, it certainly looked at that point like this idea of an Anadarko washout might be here to stay and might deserve to be kind of, monitored closely. So immediately some commentators sort of came out and questioned whether Cimarex had been decided correctly. A lot of people were talking about it, and then it sort of faded into the background a little bit. It was a big topic of conversation a few years ago, and then there weren't any other cases about it. People started to look at it as, was this maybe an anomaly? Let's just make sure we've got our operating agreement signed, etc. Then along comes Cromwell, and here the El Paso Court of Appeals really doubles down on the Anadarko washout. So and that case was styled as Cromwell v. Onshore, but by the way, Onshore is an Anadarko entity. So once again, this, Anadarko was kind of the culprit here. So here, Onshore owned substantial working interests under multiple sections of land and circulated JOAs among various working interest owners. Cromwell also acquired 2 leases in this same JOA contract area that had not been made subject to these JOAs. Each of these leases had the typical Habendum clause reading so long thereafter as oil and gas is produced from said land. So, again, your standard passive Habendum clause. Anadarko, again, never responded when asked multiple times by Cromwell to execute a JOA. Anadarko then drilled 3 producing wells on Cromwell's leases, which paid out in or around August of 2009. After these wells paid out, Cromwell was presented with joint interest billings, or JIBs, reflecting the share of operating expenses chargeable to his working interest. So he received JIBs, he paid JIBs. Sometimes Cromwell was paying Anadarko, other times his operational costs were subtracted from his revenue check, just depending on the sale of production in that particular time frame. And Cromwell also received an AFE to replace a compressor. They specifically cited this in the case that referred to him as a working interest owner. So, Cromwell felt pretty good about all this. He paid his share. He paid his JIBs. He agreed to his AFEs. He consented to, operations. But Anadarko later came back and said, look, these activities were just a mistake. We didn't really mean to do that. We just kind of weren't really paying attention. So fast forward a few years, the primary terms of the Cromwell leases expire. This is now in 2012 up through 2014. And Anadarko, after the expiration of the primary term, continues to send Cromwell joint interest billings and cutting him revenue checks as though he's a working interest owner. It also continued communicating with Cromwell as if his leases were still effective. So Anadarko doesn't really raise this issue. Everything just kind of goes along. The parties are getting along just fine. Everybody's happy. So some of the examples, or one example cited in the case was Anadarko sent Cromwell a letter about revenue netting in April of 2014, referring to him as an owner. He got a division order in 2015 asking him to certify his ownership interest. No real red flags there. In 2016, it listed Cromwell as a working interest owner on an exhibit to a joint operating agreement. And its internal records listed one of Cromwell's leases as held by production. Anadarko once again claims, I'm sorry guys, we just screwed up, our bad. We made a mistake here. All of this was kind of an error. And it turns out, Cromwell, your leases expired at the end of their primary terms. Even then, Anadarko continued to pay Cromwell. So then in 2017, Anadarko took new leases, or once again, top leases, depending on your perspective in this case, and kind of leads us to Cromwell's argument. So Cromwell obviously is not happy about this. He says, look, production in paying quantities was achieved on the lease, and that was all the lease required. What more was I supposed to do here? Not only that, but Cromwell tried to distinguish this situation from Cimarex because he said, look, I did exactly what Cimarex didn't. I participated in production. I shared in the costs. I shared in the risks. I shared in the liability. Cromwell, again, paid his proportionate share of various costs in the well, accepted Anadarko's proposal to fund a new compressor, paid for damages related to the well, reimbursed costs, paid interest. This is all set forth in the facts of the case. So he says, look, I wouldn't have done any of this if I were a quote unquote non-participating co-tenant. He argued, look, this is constructive participation sufficient to perpetuate my lease and imply an operating agreement. So again, this is going back to the fact that the parties, both in Cimarex and Cromwell, wanted to kind of argue for a constructive operating agreement. This is an equitable or an estoppel argument, where they're saying, look, we've gone all this way. I've gone to all this expense. You're now kind of stopped from denying the fact that we have an operating agreement. We've agreed to operate this well jointly. The only thing he didn't do was ever actually sign an operating agreement. Anadarko comes back and says, look, none of that matters. This is exactly the same thing as Cimarex. Cromwell, you had to have actually caused the production of oil and gas to extend your lease beyond its primary term. So what does that mean then? Well, to cause production, a lessee must do something, quote from the court, to bring about the production. For example, it must drill wells itself, assign its interest to someone else, farm it out, pool the lease with others and benefit from their drilling, or enter into a JOA with a drilling co-tenant. Cromwell did pay operating expenses incurred after production was obtained, but did not share in the costs of drilling and completing. So Anadarko tries to distinguish, look, these were operating expenses. these were not the cost of drilling and completing. We still shouldered that portion of the risk, you know, and you were still kind of treated to that extent as a co-tenant. And not as an operating agreement partner. These were not participating or joint operating expenses because, again, they did not share in the risk of a dry hole or the risk that this will be a marginally producing well that never actually pays out. Hot take, you know, is this a distinction without a difference? I don't know, maybe. We'll let the Supreme Court weigh in on that. And remember, you know, Anadarko did refuse to circulate a JOA. Cromwell, you know, asked for one. Cromwell did everything he would have, you know, been expected to do under a JOA. But, you know, did he knowingly take the risk that the other tenants on the land might refuse to sign a JOA and force him to commence production on his own? Possibly. So the Cromwell court squarely applies Cimarex here. They look back and say, this is the exact same thing. You know, I don't see any reason to deviate. So they say, look, Cromwell's action was insufficient to maintain his leases under Cimarex. Cromwell had to do something, take some action to cause production to keep his leases alive. He had to take this action despite the fact that this is a passive Habendum clause that just says that the lease will be, you know, perpetuated if there is production. It doesn't specify whose production or say that, you know, there has to be an operating agreement signed. The court rejected this idea of constructive participation, this idea that there was a constructive JOA created, and said, look, the leases expired at the end of the primary term because Cromwell did not cause the production. The court stated that Cromwell's participation was substantially the same as Cimarex's, so, you know, they didn't see any real reason to distinguish the facts of Cromwell from the facts of Cimarex, even though, you know, purportedly Cromwell did a lot of things that Cimarex didn't do. And as in Cimarex, Cromwell's payment of invoice costs did not amount to constructive participation. And look, the El Paso Court of Appeals has made it very clear that they think paying jibs is not enough to maintain your lease. So you've got to do something more, and most likely it's got to be sign an operating agreement. So again, this constructive participation argument falls on deaf ears. His proportionate shares of the well's operating expenses are merely what would ordinarily be owed by a non-participating co-tenant, or could be netted from their production or whatever. So again, the court's drawing this distinction between participation or sharing in risk, which is not owed by a co-tenant, and operating expenses once a well is drilled and producing, which is owed by a co-tenant. So, you know, the court's kind of bending over backwards to find arguments around this constructive JOA argument. So could it be that a constructive JOA might be found under different facts? I think that is still an open question, but they certainly didn't find it under these facts. Again, Cromwell did not shoulder any risk or liabilities inherent in the operation of the well. He paid jibs, but these weren't development costs, these were operational costs. You know, and a producing co-tenant is entitled to be reimbursed out of production if and when production results. And you know, just as Cimarex's payment for repair costs and equipment payments were not constructive participation, Cromwell's jibbed costs were not constructive participation either. So we're seeing a trend forming here. Then there was this working interest owner argument. They said, look, you kept calling us a working interest owner. We had no reason to believe we weren't going to be treated as a working interest owner. The court didn't like this either. The court said, look, you know, referring to you as a working interest owner didn't change anything. There was no real detrimental reliance here that would lead to an estoppel type theory. You know, these were just mistaken communications. This course of conduct argument cannot overcome the absence of a signed JOA. That argument, of course, being that we formed a JOA through our conduct. And again, you know, the court seemed sympathetic to Anadarko having mistakenly treated Cromwell as if his leases had not expired for years after their primary terms by sending jibs, paying revenue, accepting payments. You know, the court said, look, there's no real reason to give credence to any kind of estoppel or ratification or constructive JOA theory here. In fact, ratification wasn't really brought up anywhere in either of these lawsuits. The court also made an offhand comment that special limitations, here being the Habendum clause itself, are not a forfeiture. So they try to draw this distinction and say that it's not a forfeiture, it's a special limitation. You know, I would say that there are cases, you know, that cut against that. Look, again, back to the retained acreage cases that say, well, look, you know, a special limitation to avoid being a forfeiture has to be very clear and unequivocal. And one could argue that it's not very clear or unequivocal to say that this lease will be maintained if there is production, and that's all it says. Production is production. So now we get to Cromwell's petition for review. They argue kind of what we've been talking about. Look at the Endeavor case. Termination clauses have to be clear, precise, and unequivocal. They're not really trying to mince words or split hairs between what's a special limitation versus a termination versus a forfeiture. The leases do not specifically say that Cromwell had to drill his own well to keep his leases alive. Termination should not be implied from a lease's purpose. The purpose, of course, being to explore. It's a broad purpose. It's to get the oil and gas out of the ground into the marketplace. Everybody makes money. It should not mean that the lessee must personally drill and explore at all costs. That would, of course, be economic waste. Possibly also, damage the reservoir. Want to discourage lessees from cluttering acreage with their own wells. We want to discourage waste. It's against public policy. And lessee has the authority to drill under a lease, but that doesn't necessarily mean they have the obligation to drill, or if somebody else drills, that their lease can't be perpetuated. Professor Kulander also filed an amicus brief, which he does not do often. And he said, look, the express terms of the lease do not require production to be brought in by the lessee. Production is production. Cimarex didn't participate, but Cromwell did by sharing in the costs, risks, and liabilities of production. Anadarko's own records show that Cromwell, as a working interest owner to a different JOA, and showed Cromwell's leases as HBP. He's saying, look, there's plenty to support this kind of course of conduct argument as well. I mean, they called him a working interest owner. It's a little bit unfair for them to be able to recant now just to wash out his interest. So also, and this is an interesting point, these are the kind of activities that would give rise to a common law mining partnership, which then would sort of create this default operating agreement between the parties. So if leasing parties wanted the lessee to produce, it would be easy to include production by the lessee in the Habendum clause. We've seen it. There's the active Habendum clause. You can put that in there. You can make that as detailed as you want. Also, a Texas oil and gas lease, again, conveys a fee simple determinable interest in the property. Therefore, why should a lessee be treated differently than an unleased mineral co-tenant? This is a fee simple conveyance. Consider this scenario. A mineral co-tenant conveys a term mineral interest, not leasehold here, for a term of years lasting 5 years and as long thereafter as production occurs. Fairly common, conveying out a term mineral interest, a term NPRI, different types of interests like that are not leasehold. If a third-party mineral co-tenant or lessee then achieved production 1 year later, would the same rule promulgated by Cimarex apply and end the term interest in 4 years, even though the requirement of production on the caption land was clearly met? I don't think you would necessarily be arguing or making the same argument in that case. So here's a few parting thoughts on the Anadarko washout. Look, under the intent of most leases, which is to produce and sell the oil and gas, whether restrictive or permissive, production on the lease probably should be enough. Again, this is my hot take. Co-tenancy might create this idea of a common law default operating agreement that provides for an accounting procedure, recoupment of costs, to indirectly cause the drilling of a well by farming out your interest until payout. Covers just about everything but a risk penalty. Covers kind of many of the essential terms of an operating agreement if there is no operating agreement signed. Special limitations, like the courts have clearly said, these should not be broadly read into leases. They must be clear. They must be clear and unequivocal, to quote the courts. And if production must be expressly caused by the lessee, is an operating agreement even enough? How far do you want to take this argument? So, and this is kind of an absurd clause, but I mean, if you wanted to go this far, you could. You could say, as long thereafter as oil and gas is produced by the lessee, and if production is caused by anyone other than the lessee, even under the terms of an operating agreement, this lease shall not be extended into its secondary term. I mean, you could really stretch out the Habendum clause any way you want. You're free to contract. And under this kind of clause, well, I mean, clearly, only one party is going to be able to perpetuate this lease. Seems completely absurd. Why would you do this? Well, go back to the anti-Chesapeake clause. I mean, you might draft something like this to avoid a specific operator in the area that that you feel like has burned you in the past or burned your neighbors or, has a reputation or whatever. Again, no offense to our friends at Chesapeake. Not allowing for some kind of default or constructive estoppel operating agreement does seem to set the stage for bad faith working interest washouts. Be careful relying on these holdings for now. I wouldn't go, start rubbing your hands together and saying, how do we go wash out all our non-ops here? These holdings, I think, are still a bit tenuous. They're a little bit relegated to their particular facts. It could be that under different facts, you might be able to find for a constructive operating agreement. Hard to say at this point. And again, remember, Anadarko collected Gibbs, then they washed out the lease. This seems to set the stage for well-capitalized operators to withhold operating agreements, and non-ops might have no recourse. This is a common situation. To quote Brandon Durrett, calls into question the validity of thousands of existing non-operated leases in Texas that were not allowed to participate in development operations. And the solution would seem then to be that your only alternative is to drill your own well. Okay, so everybody has to drill their own well, assuming they can get, a Rule 37 exception, a Rule 38 exception, and actually get the permit to drill their well. This would obviously lead to over drilling and inefficient production, physical and economic waste. It runs afoul of the public policy to prevent waste, to maximize production and protect correlative rights. And it seems a little oddly in favor of washouts and lease forfeitures, which is something that the Texas legislature and Texas courts seem to have historically kind of been against. So where do we stand now? As of today, all eyes are on the Supreme Court. We're monitoring this closely. It's going to be interesting to see, A, whether they see reversible error and try and decide to take the case, and B, if they do, what they decide to do with it. As it stands right now, again, every operator has to drill its own well to maintain its leases if there's an operating agreement withheld. This clearly does not prevent waste. The current law as it seems to stand now seems abusive, ripe for abusive tactics. Again, Anadarko just flat refused to circulate a JOA, apparently with the intention of washing out these interests. The Habendum clause merely required production and paying quantities. This happened, all it said was there had to be production occurred. Even a savvy mineral owner could collect royalties until payout, then they could attempt to cancel the lease and fully participate in their interest, say, well, there's no JOA, we're now participating, or attempt to negotiate a new lease like we saw in Cimarex and Cromwell. So how do you avoid this thing? Well, the El Paso court, at least, has not recognized a constructive operating agreement through participating in costs, risks, and liabilities without a JOA. Now, it's possible another court of appeals could decide not to follow El Paso and go a different way, but this is what we have for now. So the gold standard, of course, is sign an operating agreement. Do everything you can, make sure you got it, make sure you actually sign it, make sure you keep a signed copy in your records and you know where it is and where to find it. Do this before the primary term lapses. Also, you could go back and amend your lease form to state specifically that any production is sufficient to extend your lease without regard to the party that caused production. I mean, you would think this is kind of encapsulated in the passive Habendum clause, but the courts clearly disagree here. Look, remember, most states make forced pooling available, but not Texas. Could we see this, then being used in other states to refuse to force pool uncommitted owners in a tract, refuse to circulate an operating agreement, starting to wash people out in other states? I mean, anything seems to be fair game at this point. So let's see, I've got a couple of minutes here, and I will quickly run through the Dorchester case, because again, this is interesting, and I'm totally switching gears now. We are no longer talking about Anadarko washout. So if anything, we're talking about Dorchester washouts now. So what happened here was back in 1983, Belmont Oil Company owned a 25% working interest in Midland County and signed a JOA with other working interest owners, and Santa Fe was named the operator. They drilled 2 wells, they began to produce. Fast forward a few years, Torch Oil and Gas succeeds to Belmont's non-operating interest. Then in 1990, Torch apparently, and this is an important fact in this case, conveys its interest to SASI Minerals and Baytech. There was no assignment actually recorded. So this is one of those mysterious assignments that's sitting in a file cabinet in somebody's office but never got recorded. Santa Fe was made aware of this change. I don't know what that means. I guess maybe they were sent a copy of the assignment or, a letter. This was kind of pre-email. I don't really know, maybe a phone call, but they were made aware. So so Santa Fe, the operator, issues a new division order to Torch saying, hey, you own 0%. Torch signs it. Kind of an interesting move anyway, but yeah, Torch signs this 0% division order. And so everybody kind of goes along, without any further disruptions at this point. Later, SASI and Baytex interests vests in Dorchester. So from May 1990 all the way through December 2016, there's nothing really happens. Dorchester acts as a non-op under the JOA. They pay their share of costs of production, shared revenues, paid royalties to lessors, made elections under the JOA. Sounds a little familiar after talking about the Cimarex and Cromwell cases. Torch did nothing to recover title between 1990 and 2016. Kind of their last act was to sign this 0% division order. Then in 2016, Torch purports to assign its interest to PBEX. Torch then sends a letter to Dorchester stating that back in 1990, they had mistakenly notified Santa Fe that Torch had assigned its leasehold to Dorchester. They had mistakenly accepted this 0% division order. And Dorchester, of course, refuses to confirm the correction. They say, no, we own this now. So Torch sues. One thing that wasn't really brought up in this case was whether PBEX, had a bona fide purchaser argument. Again, at least at the appellate level, this wasn't really argued. Maybe there's another angle here that would prevent them from being a BFP that I'm not aware of, but just wanted to throw that out there. So the issue here was whether, regardless of the existence of a valid conveyance in 1990, Dorchester had adversely possessed the non-op working interest of Torch in the subject land. So this is a kind of a novel argument, this idea of one non-op adversely possessing the interest of another non-op. So in finding that Dorchester had divested Torch and thus PBEX, their successor, the court looked to the so-called 25-year adverse possession statute, and they looked at kind of three primary questions, or I should say three primary questions kind of arose. Number one was, first of all, can a non-op interest be adversely possessed? Number two is, what would it take then to adversely possess a non-op interest? And question three was, does going non-consent interrupt continuous possession for purposes of adverse possession? So, quickly, these are kind of the generic elements for adverse possession in Texas. You've got to have an actual physical entry, usually, drilling and producing on the land, exclusive possession, a hostile or adverse claim of right, open and notorious possession, and it's got to continue for the statutory period. Texas allows tacking, so one successor to kind of tack on their time to another successor's operations. Typically, adverse possession is 10 years, but there's a couple of different statutes depending on whether you're taken under color of title or what, and all the way up to a 25-year statute, which usually has to do with adverse possessing from somebody who has some kind of a disability or doesn't have the mental faculties to go out and kind of look at their land periodically. So that's the longest adverse possession statute. So the first question, can non-op interests be adversely possessed? Torch argues that these interests aren't possessory interests in Texas and thus are not subject to adverse possession. The court squarely agrees here. They say, look, these are possessory interests, and there's no real distinction for these purposes between operated and non-operated interests. These are just working interests, which are a possessory interest. So then how do you adverse possess it? Well, actual visible appropriation of leasehold working interests, which is generally satisfied by oil and gas drilling and production. And even though Dorchester itself never set foot on the property, the minerals were drilled and produced by the operator, which satisfies this requirement. So, what's kind of being argued here is that an operator can adverse possess the interests of one non-op on behalf of another non-op, kind of an adverse possession by proxy theory. Again, everything about this case is fairly novel, not only in Texas, but everywhere. So then, does going non-consent disrupt possession? Dorchester was at times non-consent in the operations on the subject land. The court finds that this does not interrupt continuous possession, and that non-consent does not equal a relinquishment of title. Dorchester performed all the functions of a working interest owner, and they did it for 25 years. There was a strong dissent in this case, which almost always means that it's going to be appealed to the Supreme Court because the dissenting justice makes a lot of your arguments for you. He said, look, adverse possession shouldn't apply. Dorchester didn't actually drill the wells. They didn't produce anything. Even if this appropriation by proxy theory is sound, non-consent should have disrupted continuous possession over the 25-year period, actually the 26-year period. And when a party goes non-consent, they are deemed to have relinquished their interest under a JOA until applicable costs and risk penalties are recovered. So they say, look, you've given up your interest, therefore, this has kind of disrupted the continuous possession because you've kind of farmed it out or relinquished it to somebody else. Note again, this appears to be the first reported case in any jurisdiction applying adverse possession to a non-operated working interest. So interesting stuff. Points of interest, and I know I'm running out of time here. If anybody needs to jump off, I will not be offended. For those of you who wish to stick around, I'll wrap up the last couple of slides here real quick. And if an operator can adverse possess a non-operating working interest on behalf of another non-op party, are there also circumstances where the operator itself could adversely possess? I mean, certainly would seem so. At what point would the law of co-tenancy and the heightened requirements of co-tenant ouster potentially apply? This wasn't really brought up in the case. Maybe the distinction here is that one non-op is adversely possessing against another non-op's claim to the same interest, as opposed to one party trying to take another, interest out completely, a third party's interest. Is this decision at its heart based on equitable principles such as unjust enrichment, detrimental reliance, estoppel? Possibly. If it is, it's possible this case could be kind of, again, relegated to its particular facts. And maybe this doesn't open up the door for a broader, argument for adverse possession of non-op interests. Like the other cases we looked at today, beware relying on this precedent. Who knows what the future may hold. It is pending before the Texas Supreme Court. So thank you guys so much. I hope you found this interesting today. Obviously, there's a lot of open questions, but this is pretty interesting stuff. This is kind of a sort of cutting edge of what's going on at the Supreme Court level right now, and it will be very interesting to see how this plays out over the next year or so. Here are your codes for AAPL credit, CLE credit. Again, you can get your affidavit of attendance by clicking on the GoToWebinar drop-down menu, as well as these slides. We would love a post-event survey after the program has ended. I certainly know that I can always do better on these. We would love to hear different and new topics that you guys would like to learn about. We get a lot of our ideas from these surveys. A follow-up email will go out early next week with further credit information. So don't feel like you have to hit us up, though you're welcome to. This is me. I'd like to give special thanks to Michael Streetman, one of our law clerks, who helped me put this presentation together. He did a great job helping extrapolate the facts and put the cases together for me. This is my contact information. I love hearing from you guys. I love talking about this stuff. Please feel free to reach out if you have any questions or just want to introduce yourself. I usually get back to you within a couple of days, if not quicker than that. So I certainly encourage you to reach out and look forward to hearing from you. And don't forget to scan our QR code here, register for upcoming OG Energy Education Series webinars. We would love to see you. For anybody who might have missed this, pass the word along. I'll be giving basically the same presentation in Boston at the AAPL annual conference here in just a few weeks, and look forward to seeing you out there as well. Thank you very much.